The IAAF has been heavily criticized for its handling of athlete Caster Semenya. Many, including medical and human rights bodies, have slammed the World Athletic Body's new rules as discriminatory. On Tuesday, Semenya lost her appeal at the Federal Supreme Court of Switzerland against the restriction of naturally occurring testosterone levels in female runners. Now, this decision means Semenya will not be allowed to defend her Olympic title at the next Summer Games. Joining us to discuss why legal and ethical matters should also concern all of us is Professor Steve Cornelius, head of the Department of Private Law at the University of Pretoria. Professor, a very good morning to you, and thank you for your time. Before we get into the crux of the matter, let's go back a little bit and really recall what really happened between 2011 and 2013 when the IAAF instructed athletes to give both their urine and blood samples. How did we end up where we are today?
Well, I think we can go back to the Berlin World Championships in 2006 when Caster Semenya burst onto the scene and won the championships as a fairly unknown athlete. And immediately there were questions asked about her, firstly whether she is female or not, and then about testosterone levels and so on. And I think from then on it has been a campaign on the part of World Athletics to try and exclude athletes like Caster Semenya from participation. So they passed the first version of these regulations, which was then not overturned but suspended by the Court of Arbitration for Sport because of lack of evidence. They then used blood samples collected in the anti-doping process and under the pretext of anti-doping to conduct so-called research, which was then the basis for the current regulations. Now, the research on which this is based has been criticized and torn apart by scientific peers on a number of occasions, and it's fatally flawed. And nonetheless, the IAAF relied on that so-called evidence, and the Court of Arbitration for Sport upheld that in spite of the medical evidence that was presented to them. So in short, that's how we got to where we are now. Caster Semenya then appealed to the Swiss Federal Tribunal, but that is a slightly different process because there you're not directly fighting the IAAF, but you are actually fighting the Court of Arbitration for Sport, and you have to convince the Swiss court why the Court of Arbitration for Sport was not merely wrong in their decision, but why it was fatally flawed. And there's very limited scope for that appeal process. And while it's very disappointing, it's not a huge surprise that they did not overturn it, because in the past 10, 15 years, you can count the number of cases that they have overturned in any arbitration, let alone sports arbitration. You can count on your one hand.
As we try and make sense of this matter and try to follow on the calls of the Minister Natim Tetwa, who is calling for the collective nation to stand behind Caster Semenya, saying that South Africa is going to study this judgment and then decide what sort of action to take. As we face that matter and try and assess the problems with the IAAF, you've spoken about the conduct of the research and the manner in which it was done. What then stands out as a firm argument by Caster Semenya in this matter?
I think there's a number of firm arguments, and primarily amongst those is the fact that one is taking essentially healthy athletes and now turning them into patients by compelling them to take medication which is not medically prescribed. And that for me is a massive concern. If a sports federation can be allowed to compel athletes to take hormone treatments without any medical backing for the reason for doing that and no medical grounds, then, I mean, there are enormous ethical concerns about that. And even the World Medical Association came out and questioned the validity of such an action. And it's also important to keep in mind, because this is not medically prescribed, there are no medical protocols in place for treating these kinds of conditions in this setting. So it's really a concern that we don't know what we are going to do to the health of these athletes. So that's one concern. I think living in a country where violence against women is the order of the day, that's another clear example where on a global level we are committing violence against certain women by forcing them into medical treatment which is not required. And then, of course, just the way the research was conducted, there are medical protocols and scientific protocols to follow when one conducts research on human subjects. None of these protocols were followed. And from the outset, we've asked the World Athletics to provide the informed consent that was provided by athletes. And up to now, they have not been able to provide it simply because it was never obtained. And that is, in some countries, or in most countries actually, that could constitute a criminal offense. And perhaps that's the way we should go, is to start looking at criminal prosecution where they have contravened criminal law.
As we consider the options on which way to turn, and as you mentioned, the criminal aspect being a huge factor here that could lead us to some light at the end of the tunnel, what about the gross human rights violations that we look at? You've spoken to the matter of women's rights, but the human rights, the dignity of a human being.
Well, absolutely. I mean, her dignity was impaired from the moment she stepped onto that track in Berlin, and it's 14 years ago. I'm surprised at the strength of this one woman, because I would have given up a long time ago. And the fact that she's been continuing and being defiant for 14 years says a tremendous amount about her inner strength. But certainly it's a violation of her dignity and other athletes' dignities. It's a violation of their mental and physical integrity, because we're literally interfering in their bodies without any medical justification. And even the European Court of Justice have said, even if it is medically indicated, you cannot interfere medically in somebody's body unless they consent to that. So, we'll have to wait and see. One option could be also to take the matter to the European Court of Human Rights. But again, that's going to be very costly and time-consuming. And I'm not certain that it might necessarily assist Caster Semenya in resolving the matter in time for her, but it could assist other athletes who face a similar challenge.
Very well. Unfortunately, we've run out of time, but thank you so much for your time. Professor Steve Cornelius, Head of Department at the Department of Private Law at the University of Pretoria. Caster Semenya, the matter under the spotlight there as we try and find the solutions to a rather controversial matter. This is a story that we will continue to expand and broaden throughout the coming days.